All right, good evening, everyone. Welcome back to the Judicial Proceedings Committee. Today is Tuesday, January 27, 2026. We're on voting list, number 1, and we're going to start off with Senate Bill 245, and that's Josh.
Senate Bill 245 prohibits the state, a unit of local government, a county sheriff, or any agency, officer, employee, or agent of the state or unit of local government from entering into an immigration enforcement agreement. By July 1st, 2026, the state or the unit of local government, county sheriff, or agency, officer, employee, or agent of the state or unit of local government, which has an existing immigration enforcement agreement, would be required to terminate the agreement by July 1, 2026.
All right, open for discussion. Senator James.
Some guidance on, I have an amendment that we discussed a little bit, but just let me know when the right time is, and I'm not sure it's at this moment, so I just don't want to trip you up.
Amendments are private until they're introduced, so this would be the appropriate time if you'd like to introduce your amendment.
Well, I actually had told our attorney counsel to give you the amendment from last week, so it shouldn't have been private to you. And I also shared it with the President of the Senate. So, Josh, is it, I give you authority to provide the amendment? You know.
Council will then explain your amendment, and then we can discuss.
So the amendment, which is in your packet, it's number 853220/1. So it would strike the bill, so it would not ban the immigration enforcement agreements, but would rather prohibit agents or employees of state and local correctional facilities from taking certain actions related to immigration enforcement unless an individual has been charged with or convicted of a felony. It would additionally require state and local correctional facilities to report information on these actions to the Governor's Office of Crime Prevention and Policy, which would be required to make that data public. And it would additionally require that state and local correctional facilities have policies that ensure communication with the public about these kinds of operations that they do.
Thank you, Josh. If I could just indulge the committee for a minute, indulge me for a minute. Hopefully you all received a memo from me attaching a report on which this amendment is based. And that report and the idea for this I shared with the chairman on the first day of session and with the president of the Senate. I think things have changed a lot, but I'd like to continue because in Harford County we had a horrific murder that made national news and was deeply tied to the immigration issue. I have a sheriff who I have enormous respect for, who's been running a 287 jail-based program, as have some other jurisdictions in Maryland. And I'm impressed with how it's run. I've met the ICE agents who work with them. They are nothing like the people that I'm seeing on the screen, in the streets. They act nothing like it, and it's a very different kind of individual that's involved, at least with Harford County in the state of Maryland. But I was troubled. The chairman and I visited Harford County in 2024, I think. I think it was even before last year, right? I appreciated that. We got a real good tutorial on 287Gs in Harford County. Then we all got invited last year to attend Frederick County and talk to them about their program. I knew this was a germinating issue, and I was trying very hard to find what I would call very fact-driven reports and data, and not on either side a lot of hyperbole and rhetoric and complaining on both sides, and to me some misinformation on traveling everywhere. And I found a very good report from an entity that I think is nonpartisan and credible called the Migration Policy Institute, and they did a report in 2012, which is really not dated in the sense that it's relevant today. Frederick County was included. I thought this report was so excellent because without hyperbole, but just data, facts, and information, they walk through how best to do this program, which was to be highly targeted, not a universal model, which I've now learned that is what's happening in Harford County and Frederick County and perhaps all the jurisdictions. I'm not certain. Universal meaning, regardless of why the person's been picked up by the police, they'll be screened through this process and noted for deportation and connection to ICE if that is how ICE wants to proceed. The targeted means you focus on serious violent crime, and that is what the Obama administration asked for. That is what ICE had repeatedly said was the best approach until some southern states, having nothing to do with us, went down this universal model for reasons that I don't think have anything to do with law enforcement, and the report discusses that has a lot to do with deportation, but not public safety. And so this amendment does three things. It requires for these programs to continue, they must be targeted on serious violent criminals in the state of Maryland. And two, there be outreach to the affected communities. The report goes into some detail about when you regularly communicate with the affected communities, and they know that what you're doing is trying to remove only the violent, serious criminals, they also support that idea. They also want their communities to be safe, because one of the criticisms that we all know about right now is that the way it's happening now on the national level, trust is shot. Kids are not going to school. People are not going to work. They're afraid to drive, and there is no evidence, and there never will be, that that is going to improve public safety, right? So this is this targeted approach with repeated, consistent outreach to communities so they understand what the goal is, has consistently shown that they support and they buy in, their children return to school, they go to work, and life resumes, and there's trust. And then thirdly, accountability, which requires the local jurisdictions to regularly report what their activities are and provide those report publicly, to go cap, and then for the governor and the state to also release that information so it's very transparent what is going on. Now, having said that, I want to make this record because in my county it's been an important program that has had wide support that I'm sure is really deteriorating at this point, as it is in me personally. So I would like to make a motion that we consider this amendment, but I think things have really changed on the ground, and if my amendment does not succeed, I intend to vote for the bill to ban them for now, and I will make a promise to my sheriff and Sheriff Association when and if the federal government stops what it is doing, administrations change, lawfulness is returned, I would work with them to reinstate a program under the contours of what I've just described in this amendment and work with the affected communities so that we can have an effective program and not the fear and violence and murder that is happening now. So thank you for letting me speak. I would move the amendment.
Yeah, excellent. So there's a motion on the table. First, I would say, Senator, thank you very much for the report. I did read that report. It's a fantastic report. It's very comprehensive, and I suggest everyone just read that just for your own background and knowledge. You know, what you say, I'll start off where you ended. I think the reason why I would fight back against the amendment is because you're right. The manner in which this program has been utilized has not been nimble and precise and targeted. It has been abused, and I think although, and that's a federal prerogative that this administration has chosen to utilize this program, and that's why I think we need to just get out of this business, you know, right now. And so that's why, although accountability in terms of reporting, targeted enforcement are all good things, that simply just, that reality does not exist in this country today. And so for those reasons, I would resist the amendment, but there is a motion on the floor, and
second.
All right. There's been a motion on the floor. It's been seconded. So, there's a motion for a favorable. It's been seconded, and so we will roll it. And so, sorry. So just real quick. So your yes is for the amendment. A no is against the amendment. Senator West.
I've felt for quite a long time that if somebody comes to this country illegally and commits a felony, that person should be deported. However, if people come to this country and pursue the American dream, they should not be deported. And the Congress needs to get its act together and come up with new immigration laws which provide a path for those people to live in this country legally. So consistent with that, I love this amendment. I think it is exactly the right thing to do. If the amendment, I will vote for the amendment, and if the amendment passes, I will vote for the bill. But if the amendment doesn't pass, I have to vote against the bill.
Vice Chair Waldstreicher.
No on the amendment.
Senator Sidnor.
No.
Senator West.
Yes.
Senator Muse.
No.
Senator Folden.
Yes.
Senator James.
Yes.
Senator Henson.
No.
Senator Love.
No.
Senator McKay.
Yes.
Senator Charles.
No.
Chairman Smith.
No on the amendment. All right. You're folding.
So I have a few questions about the application of what we're looking to do. So the other day at the hearing, we established that this would eliminate all agreements, formal agreements with ICE by our sheriffs, correct? I said that this bill as written would eliminate all formal agreements with ICE.
That's correct.
And so, you know, it brought me into the idea that we have counties that are working with no formal agreement with ICE who are still cooperating with ICE in these deportation proceedings. Is that accurate?
That is accurate. I mean, you heard that testified to in Montgomery County. That they have policies.
So, correct. So I asked for Montgomery County's policy is what I'm getting at. And when I looked at their policy and discussing it with a couple people as well as legal, I think it's fair to say it's opaque at best. So there's a lot of questions I have in this, and I'm wondering how Montgomery County in the process that they are having this policy in place. I mean, is this supposed to be is this going to be something that this has to come into the focus of what we're going, the reality of what we're asking for in this bill. And when I say that, I want to know, and these questions weren't answered. Like I asked for this policy because I thought my questions from the hearing the other day might get some answers. And the only thing it's done is add more uncertainty to the process. The one thing about the 287G program is that it defines a clear process for everyone, regardless of immigration status, when they're brought into a detention facility. My question is, and it's still not been answered, is Montgomery County, when they pull somebody into their detention center, they're not going to know if there's a detainer on file. So what is the process? What's the standard that they're using to determine whether or not to contact ICE on the phone, because they don't have access to a computer, which is what agencies have that work in the 287G program. Montgomery County is not one of those agencies. So what is their process for someone that is at intake, committed a crime, and how do they know that that person is illegal to contact ICE to verify if there's a detainer or not? That's my first question.
But I know that they're actually in the process of refining their policy.
Understood, but right now they have a policy that legally has some legal standing or should have that could create issues.
To my understanding, I mean, we did get some information from the county, a letter, and then also a copy of their policy. It's my understanding that, go ahead.
No, go ahead, Mr. Chairman, I apologize.
It's my understanding that at the intake piece, that's all uniform regardless of, you know, who you are. So in terms of screening questions.
I understand that.
Yeah.
But how do they know then to contact ICE? At what point? Is there identifying factor? What is the circumstance that requires them, that triggers the response by them to say, you know what, we need to contact ICE to see if there's a detainer on this person, because they're not going to know. They're not going to know.
They'll know if there's a detainer, but also.
They won't know until they contact them.
Yeah, but they'll know if there's a detainer, but and what was articulated from the president was that they basically bifurcated for charge, like if it's a certain charge or for arrest for a certain offense.
Then they would,
Go ahead and-
then regardless of race, sex, anything like that, they would contact ICE just to determine if they were here legally or not? Based on a citizenship question? So, okay, all right, I don't want, so that answers to a degree a little bit, I guess, about my concerns about the standardized process, because it lacks standardization. In their own policy from Montgomery County, it says, in accordance with Montgomery County Executive Order 135-19, ICE agents are not permitted to enter the non-public space of any county facility. As such, any individual being released, regardless of pending ICE request, will be released, and then there's a long black box after that. So I'm assuming it's been either redacted or it's, I don't know what is supposed to be there, because when you take that to the next sentence, it creates problems, because then it says, however, if ICE arrives prior to the release of an individual, in order to ensure public safety, they may permit the ICE authorities access into the identified areas. So it creates, again, a problem. What I heard the other day is that Montgomery County works with ICE, but only on certain charges. What I'm hearing today is that potentially, and I'm not holding anybody to a standard that's saying that they're required to, whatever their process is, but there's problems within this whole thing that is not a standardized process, which would open up legality issues. I would think for the ACLU would love to see a policy like this, because they could pick it apart. When you go down through this, that's the concerns I had on that part of it. When I go down to the ICE detainer part of it, and we're looking at this, what is going to be, we're not for the formal agreement. So we're going to allow agencies now to not have an agreement, but we're going to allow them to create a policy potentially that opens up different policies for different jurisdictions.
No, that's correct. It also pushes accountability farther down for those local jurisdictions that are developing those policies consistent with their values in their jurisdictions, but
yes. The 480, I would say to that, the 287G program is exactly that. It pushes the opportunity for the local jurisdictions consistent with their populace to have a program in place that's federally accepted and federal program with federal law.
Which is, I mean, look, that goes to the merits of the bill, which is that.
Understood, which the merits of the bill bring me to the constitutionality of it as well.
Just in terms of the ability or the, the propensity to dragnet people that are arrested, accused for very pedestrian things. When you have an agreement, you've got to make that contact, and that you have the ability to dragnet a lot of people that are not threats to public safety. And I think that's the policy choice that we're looking to make today.
Okay. And then the last thing, or not the last thing, I have, I think, two more, but we have no ICE agents, we have no deputized law enforcement officers in Maryland currently deputized as ICE agents.
We have the warrant service officer model and the jail enforcement officers. It's correctional officers only.
Correctional officers, thank you. The last thing I have is that under this own, again, going back to this, is, a lot of things I heard was concerns about due process, that somehow entering into an agreement violates due process. But I would like to point out that by Montgomery County's own policy, in page 1 of the classification for ICE detainers, under classification 3, serious crimes, the first thing that it says is aliens charged with a serious crime, that this is their classifications for ICE detainers. This relates to the current pending charge only, which means it has not been adjudicated.
I'm not endorsing any of the policies that are on. I mean, I'm not intimately familiar with all the 8 policies that I'm aware of, but I'm not here to endorse a policy. I'm here to.
So we're taking, that's my point though.
Yeah.
We're taking away a legal document that has been used in different jurisdictions in partnership with the federal government over multiple jurisdictions, over multiple leadership changes at the White House. And we are now deciding that today is this time that we're going to allow the lack of due process to now be handed down to the locals for a policy, not to codify. We want to codify something that allows them to have a policy, but not have a formal written agreement, which has a standardized process to now put the onus on the counties to adopt a policy.
Well, look, I mean, the agreements themselves, we talked about the whole bypass of due process, and that was, and until we pass this bill, will be the case. But for the policies, I mean, believe me, they will be heavily scrutinized in those local jurisdictions to ensure that the highest standards and that due process is afforded to folks. But that's something that I can't control from here. But
and I
it's a
appreciate
discussion that will definitely happen.
And thank you for that. But so, unlike the next bill where we're going to dictate a policy to the local jurisdictions from a body, we're going to pass legislation that restricts a cooperative agreement with another federal law enforcement partner to leave that now up to policy at local jurisdictions with zero guidance from this body that's removing this ability to enter into those agreements. Is that what I'm hearing?
I think what you're hearing is that the current agreements are rife with abuse, and we are removing those from the state of Maryland so that we can have further discussions and further scrutiny at the local level as well.
But this body's giving zero guidance on the policies. They're removing 287G without anything in language in the bill to give proper guidance to the local
No,
counties.
I think that's fair. I mean, that's fair. We're not.
That's
we're
the
getting
point
out
I'm
of the
making.
agreements with ICE.
Yeah, that's the point I'm
because of
making.
the
So
propensity
with
for
that,
abuse.
I appreciate your time. Thank you, Mr. Chair.
Senator McKay.
Thank you, Mr. Chair. I guess it'd be a question to you, sir. So we're in this legislation, we are getting rid of the jail enforcement model. Are we getting rid of the warrant service officer model as well?
Yes. So all of the agreements would be precluded under this bill. So the 8 agreements, or maybe I think Wacomico County just started theirs last week.
They signed it.
They signed it just recently. So all those agreements would be done away with. So
Is said bill taking consideration the testimony that we had where it seemed to me the warrant service officer model was very similar to what they're doing with the Trust Act in the manner in which it's the process?
I'm not sure that's true, but it's certainly it's a lighter version of the jail enforcement model, if you will. But I don't think it does not mirror what we're doing here, which is just getting rid of the agreements.
Well, according to the Trust Act, I believe they're not picking universal. I'm sorry? No, I'm talking about the MoCo's legislation about the Trust Act. They basically were picking up the phone when they saw that it was warranted that they should make that type of a phone call. That's what the president explained of what was in the Trust Act mirrored, it sounded to me, what the warrant service model was. I mean, other than a piece of paper saying.
Well, I mean, in the sense that in Montgomery County, they are choosing, there's a tiered system of offenses that they're choosing to make contact with. The warrant service officer model is indiscriminate in that regard. So everyone is getting the sweep. So there's a clear difference there.
So you're saying that.
It's a policy choice that the Montgomery County has made.
So the policy choice of a warrant service officer model is everybody is asked the exact same question regardless of where they're at, compared to what we heard about MoCo's is that they pick and choose.
Yeah.
So the distinction between the jail enforcement and the warrant service officer model, at least, according to the agreements themselves, is that under the jail enforcement model, the correctional facility does a sort of comprehensive screening of everyone who comes in and sort of proactively reaches out to ICE on, suspected non-citizens. The warrant service officer model is a little bit more limited in that they do a check for ICE detainers on everyone who comes in. At least this is according to how, the agreements themselves are worded. I can't speak to necessarily what the exact practice on the ground is, but, the more limited warrant service officer model is they just check for the existing detainers and comply with the detainers. Again, there might be a choice on the ground about which detainers to comply with, but under the terms of the agreement, essentially you check everyone for detainers and you comply with the detainers when they come up. That's the warrant service officer model.
Okay, so I appreciate you clearing up the warrant service officer model, but the president of Montgomery County Council said that they pick and choose. So it would seem to me, if we want to be fair and we want to paint with an even brush, we would want to embrace the warrant service officer model. I know we can't control what Montgomery County is going to do or not going to do, but talk about putting people in jeopardy. I don't.
Again, I mean, the thing with the warrant service officer model is it's indiscriminate, so it's everybody. And if there's a detainer there, then that they will honor that detainer, but it's indiscriminate. Whereas what they've chosen to do in Montgomery County is they've provided for a list and of some rather serious offenses that they've chosen to say, hey, listen, under these circumstances, for these serious offenses, we're going to go ahead and initiate contact. So it's a policy choice that they've made. But again, like I go back to with the warrant service officer model, it's indiscriminate. And so you're going to sweep in people that are not threats to society and who have been ensnared. So, I mean, it's just a much more broad sweep.
But have a detainer.
Yeah. They might have a detainer, yeah.
Okay, so can you address any unintended consequences that this may come? I tend to believe that what I have seen in the media, while I'm not a scholar in Minnesota by any stretch of the imagination, and some would say I'm not a scholar here in Maryland. But that being the case, are we concerned that we're going to bring what's happening in Minnesota, which is not right and it is wrong, that we're going to be bringing it in? I mean, we heard testimony from the sheriffs that said that's exactly what's going to happen. I would hate for them to be a harbinger that the unintended consequences are that we're going to actually, while we think we're having a public safety trade-off, we're actually going to put people in harm's way. I'm just trying to understand the purpose.
No, I thought about that too. I mean, look, I look to Virginia, that the governor just signed an executive order. You haven't seen kind of a flighting in of ICE agents into Virginia and other jurisdictions that have done this. In terms of, funding and things like that, there are district court cases working their way through in Illinois and New Jersey, one that dealt with VOCA funding, one that dealt with disaster relief funding, that the president threatened to withhold that money because they were deemed as so-called sanctuary jurisdictions. The courts have stopped that. So you're seeing the courts put a hold on unconstitutional activity. I got to tell you, if you can tell me what this president will do on a day-to-day, hour-to-hour, second-to-second basis, then you are the $64 million man. But
it would be probably more than worth $64 million.
But I do think it's important for us to put our values into statute and into the law. You are dealing with an asymmetric actor. You cannot control what he's going to do. We might as well step up and enshrine our values into the statute and into the law.
Now, unfortunately, I'm going to have to vote against this, just for the simple fact that I do believe that the bill entertaining the scope, because it is taking out the warrant service officer model, which we heard was actually very similar, and actually I think does a better job than what MoCo is doing. Second of all, we heard the testimony by the sheriffs that we believe that this was actually going to bring unintended consequences. And I hope that the state of Maryland, JPR advancing this to the Senate, is not playing with house money, and that they're rolling the dice. Because I'm telling you, I don't want to be the harbinger. I'm going to tell you, we're going to have unintended consequences off this. And policy making is hard. I mentioned about Senate President Bill Ferguson talking about that I felt that he was a plumb line when it came to policy making. And sometimes those policy things are not necessarily what the general public wants. But boy, I am glad that the General Assembly in Maryland doesn't listen to Facebook and listen to social media, because we would be in a world of hurt. So I'm hoping I'm going to be wrong, but I'm telling you, we made there was a right decision to vote for the amendment that Senator Mary Delaney put up. And it's a shame we missed that opportunity, but thank you for answering the question, sir.
Thank you, Mr. Chair. I just want to correct the record, because it's been said a couple of times that, if we do this, we will be inviting what's happening in Minnesota. And I want to make it clear that Minnesota, several of their jurisdictions have 287G agreements. So it's not because they don't have them that this activity is happening. And if we get rid of them, we will invite this activity. Those two are not equal. So I just wanted to make sure the record was clear that Minnesota does have 287G agreements.
I would just like to say, to correct the record, that is an opinion. I don't believe we're comparing apples to oranges, and I tend to believe that what's happening in Minnesota is a series of decisions that have been made by the state legislature and those that have warranted it. So.
Thank you. I also would like to clear the record that the jurisdictions that are using 287G are not the ones in Minnesota, Minneapolis, where we're seeing all the destruction and the action by people interfering with an official law enforcement act. So, for the record.
Thank you. I have a question for a clarification. So without going back over my amendment too much, but there's an enormous amount of discretion with 287s, and that's why it's gotten hijacked following these southern states that decided to stop making it targeted, which is what it was supposed to be, because the evidence says that's the most effective way. The universal is almost like shooting yourself in the foot, but that's beside the point. Getting rid of this, what I wanted to make clear, I think, is that local jurisdictions can still, as Montgomery County is sort of showing, can still have relationships with the federal government immigration to address serious criminality from people here illegally if they're prioritizing it. This does not stop what predated 287s. It wasn't like we were sitting around with our hands tied behind our back blindfolded, but there was, efforts to keep people safe from serious criminals. So, right, I just want to clarify, I'm not aware that this bill goes beyond the 287s that are currently in place, but not anything else, any other agreement, because I don't read that in the statute. Am I correct about that? Right?
So, yeah, I mean, that's an accurate description.
Okay.
Just agreements, not policy.
Yeah, very good. I think that was it. I just wanted that clarification. Thank you.
All right, so there's been a motion that's been seconded. We've had significant debate. I'd like to roll the bill.
Vice Chair Waldstraker.
Yes.
Senator Sidnor.
Yes.
Senator West.
No.
Senator Muse.
Yes.
Senator Folden.
No.
Senator James.
Yes.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
Nay.
Senator Charles.
Yes.
Chairman Smith.
Yes.
8-3.
Senate Bill 245 passes 8-3. Senate Bill 245 passes 8-3. All right. We'll now move on to Senate Bill 1.
Go ahead.
Yeah.
Senate Bill 1 requires the Maryland Police Training and Standards Commission to develop a model policy prohibiting the use of face covering by a law enforcement officer in the course of duty. A law enforcement agency with law enforcement officers operating in the state must adopt a policy consistent with the model policy developed by MPTSC under the bill. The bill also prohibits a law enforcement officer from wearing a face covering while in the performance of duty in the state, except as authorized in the policy adopted by the law enforcement agency pursuant to the bill. This prohibition does not apply to a law enforcement officer actively engaged in an undercover operation. Finally, the bill establishes penalties for a violation of the prohibition, specifically misdemeanor 2-year $2,000. There is one amendment in your voting packet. The amendment does a couple of things. First, it requires, instead of MPTSC adopting a model policy, MPTSC would adopt a uniform policy and provides that MPTSC's policy may allow for uses of face coverings under circumstances absolutely necessary to protect the health or safety of law enforcement officers while performing public safety functions. The amendment prohibits a county, municipality, or a law enforcement agency of the state or political subdivision of the state from adopting a policy other than the uniform policy regarding the use of face coverings by law enforcement officers. Instead of a criminal violation, the amendment would make the penalty a civil offense subject to a $1,500 fine. It adds procedural language regarding the form, issuance, and court proceedings involving a citation under the bill. It also makes conforming changes.
I'd like to adopt the amendment and then work off of the amended language.
I had a question for the, but you can wait. Go ahead.
Okay. Move the amendment. It's been seconded. Is everyone okay with the with adopting the amendment? All right. Now the bill's before you as amended discussion. Let's go to Senator James.
Thank you, and thank you for this amendment. I don't know if you will recall, I had an exchange with Senator Augustine in which I had a concern about the way the bill was pitched, the language of it, where it sort of, came out saying, we're not going to allow for this, but then we're going to have a model policy. It looks to me like this is an improvement, that this language then sort of takes into account that concern and adjusts it so that, there'll be a uniform policy. We're not predetermining it other than making it clear that it's, face coverings should be in, extremely necessary circumstances, as opposed to the way it was drafted. Am I summarizing that correctly, or am I missing something? It seems to me it's an improvement to, at least regarding the conversation I was having with the senator.
That's right. There are two things. That one is that there's some language there that it preempts. Whatever the policy that comes from MPTSC,
Right.
Which of course there's, it's a considerable amount of discretion for them to understand and as experts develop the right policies
Right.
for their members. So the exceptions that would be, we're not overly prescriptive in that sense.
Right.
And then it makes it uniform throughout the state, meaning that it's got to be consistent. So there's preemption language that all 24 jurisdictions would have to adhere to what MPTSC does.
All right. Thank you, Mr. Chairman.
Thank you, Mr. Chair. Jamie, so we had a little discussion about some of my concerns. I still have the concerns about primarily what authority does a state or does the state have to dictate federal law enforcement policy or procedure, specifically because it's relative to the idea that we've turned this procedurally speaking over to MPTC to adopt a uniform policy. So now that policy has no governance, like it would be applicable to Maryland law enforcement. Completely understood that. One of the components of this is that Maryland law enforcement, because they fall under the guidance of MPCTC, would be that they would be trained on that. Because training is an important element, because intent is also an important element of crime. So if we have a body that has no jurisdiction over federal partners to implement a policy that has no jurisdiction over federal partners, and we're not training our federal partners that there is a violation, potentially conflict and contrary to local law, it goes back to the supremacy clause that I've been trying to establish all along with you guys. So my question is, are we training federal agents after the implementation of the policy? Because if you don't have the intent to commit a crime, how are you going to, or this is civil, so I removed that prior statement about the crime. So that would be my first question, is how do we have, where are we at on this, have we learned anything additional since the hearing that deals with us being able to dictate policy to the federal government?
Look, I'll let Jamie kind of build on what I say, but one thing is, look, I mean, once you pass a law here in Maryland, then you are putting everyone, feds included, on notice that this is kind of the law that governs this jurisdiction. The feds, to my knowledge, they don't have, ICE does not have a policy that they.
It's discretionary.
It's discretionary, so there's no
So that is their
formalized,
policy.
there is no formalized. The policy is that there is no policy.
There's discretion. It's officer discretion
Yeah, yeah.
or agent discretion.
The policy is that there's no formal policy.
Sure.
So I think, so, where you're going to push this is when someone tries to enforce it through a civil.
And that was my next question, which is functionally, how does this,
So
how does the issuance
we
occur?
can walk through that. There are obviously some Fourth Amendment things that are in play. Then there are also
yeah.
supremacy clause issues that are in play.
There's a lot of those.
But I'll let Jamie
Sure.
speak a
Thank
little
you.
bit more, and then I can come back to the Fourth Amendment piece and to
Sure.
the supremacy clause piece.
Thank you.
Sure, and Senator, just so I understand, did you want me to walk you through the supremacy clause?
So I'm asking basically what authority, so I think the chairman kind of answered that if we're passing a law, even though the law then has to be handed off to, I'm not sure I've ever seen a law where we hand it off to, I mean, I guess we do with some like food law or liquor violations or something to local municipal or local agencies, but where we have them establish a statewide board, establish a policy, which can totally do. I'm not saying that they can't do that for local and Maryland law enforcement. Where I take exception is the idea that they can have that policy, which is said in the bill, that would be, they would make a uniform policy that would then fall into a civil issuance of a citation for failure to comply with a policy that they'd never be trained on.
Sure. Just so I'm clear, I mean, I could weigh in on the federalism issue for you, or
Sure. I mean, we can start there.
yeah, and I candidly reached out to the Attorney General's office for a little bit more background and some analysis on the federalism issue here. And to be completely honest, I think it's a fact-specific inquiry. It's a more complicated analysis as to whether the state can hold a federal agent criminally liable, or in this case, liable for a civil offense while in the performance of their duties. And just to.
So did you get an answer from the Attorney General's office?
Can you
Like,
talk about the two parts?
I appreciate that you reached out and asked them, I do.
Sure,
After our discussion last night, but what was the outcome of that discussion then?
And just to help, if you could talk about the two-part test and then even go to the 18.
Sure, just
Yeah, yeah.
just going through Neagle and
Yes.
and that test. So in general, under the U.S. Constitution supremacy clause and related intergovernmental immunity doctrine, in general, states cannot directly interfere with or regulate the operations of the federal government, and that stems from McCullough versus Maryland, going back to 1819.
Even in 1819, Maryland had an issue with the federal government? Interesting. 200 years later, we're still here.
So to continue off of that, there was a case in 1890, in Neagle, which held that if a charged federal officer is held in the state court to answer for an act which he was authorized to do by the law of the United States, which it was his duty to do as a marshal of the United States, and if doing that act he did no more than what was necessary and proper for him to do, he cannot be guilty of a crime under the state law. However, to determine whether an act was within the federal officer's duty, the court must look to whether the federal agent's act was done pursuant to the law of the United States and in the line of duty. That's from California versus Dotson, 2012 Westlaw 190 4466-7.
So that's my question. Both those seem to reinforce the idea that the state has no right to dictate as long as they're legally within the framework of their sworn obligation.
So I think where maybe a point of distinction could come up there is that whether let me make sure I've got this right, that it was done pursuant to the law of the United States and in the line of duty. I think that there's been some suggestion, and I wouldn't come down on one side or the other of it, but there's been some suggestion that that actually could be an important consideration based on whether ICE actually has a policy requiring face coverings or if it's just discretion.
No. The difference is a policy does not, it's in the process of enforcing federal law. They're not doing it outside the framework that they're allowed to. So the policy is irrelevant as far as constitutionality. Are they enforcing the law that they took an oath to enforce? And are they staying within the framework, the guardrails of that law? If the answer is yes, the policy about what they can wear is irrelevant.
Well, and Senator, like I said before, I'm not going to fall down on either side of that. I just want to bring you.
Yeah, no, and I appreciate it, Jamie. Thank you for looking at that. But my question comes back to what I asked you initially. What was the AG's answer? Not what you researched, because I do appreciate you researching that, because that's been great information.
So the AG's answer, just to summarize, was that it's a fact-specific inquiry and that it's not clearly unconstitutional.
Not clearly unconstitutional?
Right.
Okay, that's what I love to see from the Attorney General's office, because that means it's unconstitutional. It's just they're trying to figure out how to make it not unconstitutional.
And Senator, with your permission, there's a second part to the
Sure, I apologize.
to the legal test.
Yes.
So in addition to be entitled to immunity under the Supremacy Clause, the federal law enforcement officer must do more than is necessary and proper in the performance of the officer's duty. To meet this standard, two conditions must be satisfied. First, the actor must subjectively believe that his action is justified, and two, that belief must be objectively reasonable.
Yeah, and that is excellent points, and I appreciate you researching that, because that, again, validates the points that I'm trying to make here. Through whatever federal administration we've had, there has been federal officers, boots on the ground, in every state, deporting citizens through the Biden administration, albeit far less during those years, the previous administration, Obama's administration, the Bush administration, the Clinton administration. They all deported a lot of people. Now we're having this issue because, you know, I hear about tactics. The tactics have changed. The tactics have changed. We're in a different time than when this law was first implemented, as far as, you know, under Bill Clinton passing this through Congress in 1996 and wanting to move this forward and have people wait their place in line. We didn't have doxing to the degree that we have now. We didn't have the immediacy of people videoing and then posting it up on an internet with immediate consequences. So yeah, there has been tactics change to evolve with the times as they have changed. So I appreciate those answers. Now, I do have a question. Functionally speaking, I'll go back to this one now. Functionally speaking, how would this be handled in the state? Because it's not clearly unconstitutional by the AG's opinion. So how would most civil citations, we had this discussion earlier, so I want, you know, we were talking about most civil violations are camera related in the traffic article, correct? Like red light, I'm sorry, civil violations, apologies, were like red light cameras, speeding cameras, and bus lanes, things like that, right?
So in the context of the transportation article, you're correct. I think virtually every civil offense in the transportation article is
it's mailed out.
Sorry, every civil offense in the transportation article is like an automated enforcement
Correct. So
violation.
it's basically mailed out.
There are other civil violations throughout the code, if you'd like me to go over them.
Well, what would be another civil violation where you have an officer detaining someone?
Well, in the criminal article, you'd have a handful of civil offenses: unauthorized gambling, salvia, underage possession of tobacco, civil amount of marijuana possession.
Correct.
And what do you mean by detained? Talk about the difference between.
So, yeah, so,
Just be, I want that on the record. Just when you say detained, can you please?
yeah, I want that, I want to know what civil violations authorizes a police officer for a civil detention for processing of paperwork? Because the ones we spoke about earlier, and I, again, extremely grateful with our dialogue and you know, learning with some of this stuff with you about like the speed cameras and all that, because they're issued via mail. There's no immediacy. There's not an immediate cause and effect that requires that or is going to provide for that person to be stopped immediately, right?
Totally understand what you mean.
And it's issued to the owner,
Yeah.
not necessarily the violator.
Right.
The difference between this one and like the marijuana one or the underage cigarettes or the like, or alcohol, those are civil violations. If I walk up to you as a uniformed police officer, like, is there other areas that you were talking about, and I apologize, but that there is authority for a civil detention to issue the paperwork?
Right. So forgive me for giving maybe a more complicated answer, but throughout the code and in each of these places where the General Assembly has adopted a civil offense, not all of them, and it's not always uniform language. But there usually is a provision in the law that provides for the authority of the officer to issue a civil citation, provides for the form and issuance of that citation, and then prescribes that the district court would need to forward a summons for trial on the violation, prepayment, et cetera. Now, that's different than what the constitutional authority is, because when we start talking about an actual detention, and let me be clear, when we're talking about a detention, it's really that interaction, that slight interaction, that minimal interaction of issuing somebody a ticket. You do it when you get pulled over and the police officer, you know, takes your license and registration and writes you a ticket. That is a seizure for Fourth Amendment purposes. You have been briefly detained. And so too, would you be briefly detained for a civil violation? So last night,
That's my question.
Right.
Are you lawfully detained for a civil infraction for those type of situations where an officer issues what is commonly known as a Form 28, a CR or a DC 28 uniform civil citation for alcohol, marijuana, or, you know, especially once the officer has officially been identified, walks up and asks for ID?
Sure.
Is that a lawful detention under a civil purview?
So in general, probably. And if you'd like, I can go into the
No, it's okay. I just needed to hear that part, because this leads me to the next part of this, which is if you have a federal partner, because you're like, generally, that is the case. If someone refuses to give an ID, it does escalate things to where it becomes an obstruction issue, right? I think, fair to say?
So just to clarify, so I understand, are you saying if somebody is approached by a law enforcement officer and says no, like, or it gives them the wrong name or something like that? Well, you'd be providing false information to a law enforcement officer.
It becomes a criminal act.
It could, conceivably.
But going back to my point is, civil citation still allows, under the current doctrine that we're talking, would be that the officer would have authority to detain someone for a civil issue. For processing of the paperwork.
The same, I mean, yes, it's a brief detention.
Perfect. Understood. This goes back to the question that I had, where I'm not even getting into the part where we were talking about the obstruction or not providing ID. That, I think we've agreed that that's obviously leads down a different path. What I'm talking about is functionally, the way this bill is crafted right now. How would one issue this? Because if a local law enforcement officer in uniform would walk up to a federal agent in uniform who has their face covered and says, hey, you're in violation of a civil offense code so-and-so and so-and-so, and the agent says, go pound sand, get away from me, I'm doing my job, and now we have two law enforcement officials in a discussion about the legality of him detaining him lawfully for a civil infraction that could be potentially escalated to a criminal issue at that point. Is that not correct? So we're
Just
creating a
the
clash in a
practical-
public eye.
The practical effect of it is your question.
I'm talking about the practical application because I've made the case in the framework that it is lawful for illegal detention for this civil infractions in the state of Maryland. And by doing that, would it also say, now functionally speaking, if a uniform officer went up to a federal agent who was wearing a mask, and contrary to this, not being trained on it, by the way, according to the Maryland Police Training Standards, not been trained on it, because they go to FLETC in Glencoe, Georgia, and other places for their additional trainings. They don't come to Sykesville, Maryland to get briefed on Maryland nuanced law. They stick with federal laws, which, to your point about the case law you described earlier, are they performing their job and are they within the framework of their duties? If the answer to those both is yes, the legal standard has been met that they're reasonable within their job performance. This law specifically, as it's written, could create an issue where an officer walks up and would have the authority by Maryland's authority to lawfully detain a uniformed officer for a civil or a uniformed agent for a civil violation. Correct or not?
That they would have the authority to do it.
To detain them for a civil violation. And if the federal agent walks away, would the then local police officer be granted the authority now to arrest him because that could be deemed as obstruction?
So, again, the answer to your question isn't exactly an easy one. That's all sort of.
Oh, I know, it's not an easy one, that's
It all
why.
hinges on sort of this idea of federal immunity and whether.
Correct.
Right, so.
Correct, which I'm showing that this law is in conflict because it
Can I just
doesn't matter.
say- I know what you're saying. So I got it. You've got the two-part test for the supremacy clause. I got it. For the supremacy immunity. Understood. I think one case, so there are cases for the Fourth Amendment, detainer for the issuance of the ticket. I get it.
Correct.
We know that from everything from
That's what I'm
cannabis
getting at
to
also. Thank you.
Youth curfew. That's all good, right? I mean, Maryland courts have spoken on those issues.
And this law would also rise to that
So, and then
detention.
the second part, which is maybe the criminal part you're talking about, I would direct the committee's attention towards, do you remember the Ruby Ridge case? Do you remember that in
Yes,
1992?
I do.
So an FBI sniper shot at the gentleman they were trying to get. They actually hit the wife.
Yep.
And they took that federal agent to court in Idaho. And they ultimately dropped the charges, so the question was never ultimately answered, but they were in court to talk about that issue. And so I think.
But they didn't have a civil
It's
law
more
in the books ahead of the time that could result in a
that's
criminal arrest.
I get it, but the first two prongs of the test were met. There was within the scope of their duty, and it was a reasonable,
But that goes back to,
necessary and proper for under the circumstances.
but that goes back to
So I
Graham
guess
v.
my
Connor,
answer-
where you can't have a 20/20 hindsight.
The answer
I mean,
to the
that's a
question
separate,
is we're litigating this. I mean, this is an evolving area.
like, I'm not trying to get into,
No.
the specifics of like a Graham v. Connor 20/20 hindsight where we're going to sit here and do that because that's a very serious offense. I'm talking about something that is nuanced, which is a lot of unnecessary legal chatter about the performance of a federal agent in their job and what policy they're allowed to follow or not, and if it violates how we feel that they should be doing. And now we're going to make it to where it rises to where a local officer at the direction of a local municipality's mayor who might be like, hey, I don't like them in our city. He's wearing a mask. I want him locked. I want him charged with that civil violation, which then if the agent in the performance of his duty says, go pound sand, has now obstructed, and now it rises to a criminal offense. So it's two-pronged. Does the officer have the authority? And the answer, through the legal framework and the case law you cited, he does not have the authority to intervene in a federal work. because of the supremacy clause. The second point of it is, once he does insert himself, what is the legal consequences on the department for interfering with an official police action? Because now you're arresting an officer in uniform by another officer in uniform. Those are in direct conflict.
I know this will not be to your satisfaction, but the answer.
We're waiting on the AG's opinion?
No.
Yeah.
Story of my life. No, but like, that's.
Exactly.
We don't know is the answer. I mean.
Exactly. And that's, I guess that's kind of my point is we're sitting here, we're ramming something through instead of looking for a better solution. You know, like I will tell you that, you know, my good friend down from Baltimore County, the other day, we had a discussion about this piece of legislation. And we discussed it about the mannerisms in which this body, having a supermajority, is just going to push this through because they can, regardless of consequences. What I was asking is, why didn't we reach out to the people that have relationships with our federal partners and establish a protocol with them that they have to have a uniform, like we're talking about uniform application, that they have to have uniform ID, that they have to have uniform badge, that they have to be identified who they are, not just throwing stuff on civilian clothes and being done with that. Like we haven't offered any of that. Instead, we've gone to this virtue signaling of something that is going to be clearly unconstitutional and not enforceable and will have no legal standing instead of doing something meaningful, looking for a solution. That's the point I'm getting at. Because under this, we've already appeared, and then taking it a step further, the civil infraction, Jamie, if we issue them a civil penalty and the agent takes his mask down, gives them a driver's license when they ask him to, they issue the citation, and then the agent doesn't come to court for a civil violation, what is the judge's options at that point? I'm putting all this on the record just so we understand. Correct. That's my point.
Right, again, the court probably could issue a bench
A
warrant.
body attachment or a bench warrant, correct?
And then, again, that would, the
That would-
enforceability of that depends on the immunity question.
There we go. Thank you again.
And then they could remove it to federal court.
Okay. All right. And then I guess getting to the end of this, what other civil penalties do we have in the state of Maryland that have a $1,500 penalty?
Off the top of my head, Senator, I need to go in and look. I could do it
So
quickly for you.
let me ask you this. If I am walking through a park as a police officer and I see people smoking marijuana next to a family with a couple kids there, what's the penalty, the civil penalty for somebody smoking marijuana in a public space?
I believe that's a $500 civil penalty.
It's actually 50. It's $50 for a first offense.
Oh, okay.
It's a real heavy hit. I mean, we really went after these daggone marijuana users. $50. You know, and for each second or subsequent offense, regardless of the numbers beyond that, do you know what that amount is?
I'd really want to pull up the statute.
It's $150. You can pull it up, but it's $150 on a DC 28 form.
Sure.
So we're establishing for a federal partner who is functioning within the framework of the federal law as a federal agent in the performance of their duties, whether we agree with them or not is not the issue here. The issue is this is longstanding federal law, and they're entrusted with doing their job. And we're just putting another hurdle in front of them to create an obstacle for them in the performance of their duty, to create a potential conflict with another law enforcement officer. And we are doing it at a measure that is 10 times, 30 times for a first offense of marijuana smoking in a park around children. That's the standard. It's 30 times more important to be able to go unmask a federal agent in the performance of their duties than it is to protect kids from marijuana.
Those questions obviously are not directed towards counsel, but I'll take them.
Yeah, you could, yeah,
So
thank you.
look, it's, you know, when you look at the seriousness of having an unmarked, kitted up person with a mask on, you don't know which agency they're from, you don't know what their name is, they drag you out of your car, they throw you on the ground. I mean, that rises to the level that we as a state have got to have some sort of a uniform policy that says you can't engage in that that level
On our federal partners,
of
though.
terror, though. And that's terror.
And
Like,
that's what I asked about with the discussion was why aren't we looking at an avenue that actually has a tangible outcome that would be something that would be a solution and problem solving together?
Having MPTSC comprised of experts and leaders from across the state with federal and state experience coming together to develop a policy to keep not only the law enforcement officers safe, to develop exceptions for them, but to keep the citizens of the state safe, I think is a very good solution and a path forward. I mean,
Mr. Chair, with all due respect, the idea that we're turning this over by not writing specifically language into the law, but turning the policy directive over to MPCTC by a secretary that has zero law enforcement experience overseeing that department is not okay.
I think law enforcement professionals who are comprised of, that's who sits on MPTSC, having them develop those policies.
Not all of them are
very
law
good.
enforcement professionals.
Different elements of the law enforcement profession.
But, okay, I mean, again, so the answers are that we have no answers and we're waiting that it's not clearly unconstitutional. And we have no answers for any other penalties that are remotely close to a $1,500 penalty. And we have no answers that, the answer is that if they fail to show up in court, they could be arrested for a body attachment or a warrant, right?
So functionally, like we said, yeah, there'll be a show cause, that'll be issued, and then they will ultimately remove the federal court. And
Okay, I appreciate your time. Thank you, counsel, for your answers. Thank you, Mr. Chair.
thank you. All right, we're going to go to Senator West and Senator James.
Thank you, Mr. Chair. So first of all, I'm looking at the revised bill, and the section that I was upset about when we had the hearing, well, it's, let's see. I'm looking at the reprint, so I'm on the reprint, I'm on page 2 of 4, down near the bottom, lines 25 to 28. Yes, so I was concerned, highly concerned, that the language in the original bill, which required the state to adopt a policy, a law enforcement agency with law enforcement officers operating in the state, i.e. ICE, shall adopt a policy, that was unconstitutional in the supremacy clause. That whole paragraph's been stricken, as I understand it.
That's correct.
Okay, that's good. Now, let's come back to the other. So I'm okay with page 2 of the bill. We go to page 4 now. And I was listening intently to Senator Folden's long colloquy with counsel and with the chair, committee chair. My feeling up until this point had been that because ICE does not have any policy, one way or the other, with respect to face coverings, that Maryland can adopt a rule and enforce it against anybody in Maryland, including ICE officers. But now that we have the nitty-gritty of how this is going to operate, which I find on page 2 of the amendment, namely issuing a citation containing the name and address of the law enforcement officer, my impression is that you don't have an individual ICE officer operating all by himself. You typically have a scrum of ICE officers. 6 to 16 people going after somebody. So you're going to have a situation where Maryland law enforcement is trying to accost between 6 and 16 ICE agents and say, I'm citing you for violating Maryland law. I want each of you to give me your name and address. And my guess is that they will refuse, say we're federal officers operating in Maryland. You have no authority to cite us for anything so long as we're doing our duty. And very quickly, this will go up the chain in ICE to the top. And if ICE doesn't currently have a policy, it will in short order adopt a policy on face masks. So the situation we have right now where ICE does not have a policy will quickly be reversed. That's my operating assumption. So, but Maryland's law becomes Maryland's law, and we adjourn in April. And this policy, I guess, goes into effect when? July 1st? What's the bill require? I'm sorry, October 1st. Goes into effect October 1st. So sometime after October 1st, but when we're not in session, ICE will adopt now a policy dealing with face coverings, which will be inconsistent with this, and the supremacy issue will be squarely addressed as to whether Maryland can enforce a policy on ICE agents which is inconsistent with the policy of ICE. How are we going to deal with that? We're going to just go to court? Are we going to send squadrons of Maryland local and law enforcement officers to arrest everybody in the squadron who refuses to give their name and address, a squadron of ICE agents? I mean, my concern in general, as I indicated earlier, was that the Congress is so at sixes and sevens that they can't come to a sensible policy on immigration and haven't been able to do it for a decade. And I'm afraid we're going to do the same thing in this area. I would have hoped that the Attorney General of Maryland and the other law enforcement could have developed working relationships with the people over in the federal government. My sense is that there's no communication at all because the Attorney General spends his life suing the federal government. And we're getting ourselves into a real mess. And if we pass this bill, we're going to get ourselves into a bigger mess where Maryland law enforcement officers are trying to arrest ICE people, and they're coming before the Maryland courts. Do you have any response to this? Do you anticipate the same kind of problems that I anticipate occurring if we pass this bill? I guess I'm talking to the chair here.
Thank you, Councilman. Will it be litigated? Of course it will be. And for the reasons that we've been talking about this entire voting session, I could not tell you with certainty what the outcome would be. So will it be litigated? I'm confident.
So isn't there a better way? Isn't there a way to try to defuse the tensions rather than exacerbate them? This bill will is guaranteed to exacerbate them. Why can't we instead try to find a way of diffusing tensions? Wouldn't that be a better solution to the problem?
I mean, the best solution would be then for ICE to adhere to the policies and the law that we put in place. And that's the best solution, right? So don't wear the mask. You know. Senator James.
I know Senator Folden was trying to elicit answers to inform all of us, and I was trying to follow along, but I didn't quite keep up with it because, so I just want to kind of want to understand where we are and where we aren't. But let me start here first. So I remember having another conversation with the bill sponsor concerned about the last section of the bill on page 4, I guess from like D down, about law enforcement officers who violate this section. So I read this, that's all gone, and now we have a very, very long, elaborate, lot of language. What was the overall reason for deleting section D on down and then loading this bill up with this very detailed recitation, new and recitation of actually the way the law works in our state? So what was the driving force behind that?
As to subsection D, that's a policy call for the members that's making it from a misdemeanor to a civil offense and $1,500. I couldn't weigh in on the why of that. As for the language for subsection E on down, that language is found in other portions of the criminal article where there are civil offenses, and that really lays out that language was nearly identical. Some of it was cleaned up a little bit from older language, but
well, I didn't mean to be so vague with you. So let me just, we struck the language waives all immunity in a civil action based on violation. Sorry. So that was in and it's taken out. Why did we take that language out?
I'll defer to the.
This is just a significant policy choice that but I thought was significant that it was not necessary for the enforceability or for the merits of the bill. And I thought would
I mean, are you saying that
would
perhaps
frankly
you didn't
detract
think
from
that we
what we're really trying
the
to
state
do.
of Maryland could compel another level of government to waive an immunity that's
Yeah, I
been
mean, you're also
okay.
not, look, I mean, the
Yeah, I'm
bill
sure.
is to curtail and to encourage certain positive behaviors, not to,
Right. No, I get it. And then I guess, let me get a clear understanding of this right now. Under this bill as amended, we are asking and requiring all state and local law enforcement in the state of Maryland to, when they witness or have reasonable, whatever the reasonable suspicion or believe, that that the law requires them to go out and civilly cite any and all federal, immigration officials who violate this law. That is what this will ask our state law enforcement, state and local law enforcement to do. Is that generally what we're asking?
I'll let counsel answer, but it's going to be discretionary. I mean, it's officer discretion to
It is.
enforce. Yeah.
Well, I don't know. Why do you think that, sir?
Except for one of the
I'm sorry, if you would think a state or local law enforcement officer would not be shirking his duty if you witnessed the breaking of a law and said, today I don't feel like it. Where in this bill does it say he could look at that and go, I'm fine if that's true. I'm not a criminal lawyer, but I had no idea you could witness this and just ignore it.
Look, counsel, you can correct me on this. I think the only time we've compelled officer activity under these conditions, or any of these conditions, is during police reform when we had the duty to intervene.
You did what?
We created a duty to intervene. I don't think anywhere else we've compelled officers to abandon discretion and to take mandatory action apart from the duty to intervene. But counsel, maybe you can help me. Maybe just make sure if that's on the.
Okay, I don't know that either, sir. I really didn't know the answer to the question.
I mean, I can get a better answer for you. Probably take me a little bit of research
Yeah, that'd be fine.
after this, but yeah, my recollection is that while it's in statute that it is a law enforcement officer's job to enforce the laws of the
Right.
state, and so too like a state's attorney's job to represent the state. I'm trying to think of a specific example. My inclination would be that do they have a specific duty? I think we create some specific duties throughout the code, but an overall duty, my inclination is no, that it's not just because a police officer sees you speeding down the road doesn't mean that they have to write you a ticket for it or.
And the reason I'm even going down here is we are, to me, I really love and respect our state and local police officers. And they've been through a lot and they've made some mistakes, but they're now under enormous pressure. We are taking this road as opposed to another one where we are literally asking our local and state law enforcement officers to get into one of the thorniest, untested areas where there's no clear cases that say whether they should do this, can do this. We may risk clashes that could, if you think you've seen clashes already, we're risking clashes. We're asking and almost imperiling, potentially, local and state law enforcement who would go up to federal agents who are already, in the throes of intense, potentially violent and dangerous work, and asking them to inject themselves for this policy. I do not want to be part of our state or local law enforcement and federal agents clashing in any way over this. And I also don't want our citizens to get the false impression that we did this and then they're angry and start protesting that our local law enforcement are not, doing what they consider them to be doing. Did anybody talk about balancing that? I feel like we're big boys. We can certainly do stuff, but we're asking local law enforcement and state law enforcement to do this without clear authority yet. And so what was the discussion about that? Is anybody else done this, and is there any risk? I'm sorry, I'm so worried about us making it worse, not better. I want to make it better too. I do, but I want to really make it better.
So California adopted a policy. The Department of Justice is currently engaged in a lawsuit against the state of California over that.
I think the bill sponsor told me he sort of modeled to some extent this, or that.
I think California is a little bit different.
Okay.
Chiefly among that, my impression from looking at some of the filings from the California case has been that they applied it specifically to federal law enforcement officers, and not their own local law enforcement officers,
okay,
which creates a bit of a
Just one
disparity
last question
between
after that.
treatment between the federal government and everybody else.
Here's my last question, and because you can finish up with me later, because it's getting late. I just want to understand this. Later on, if you haven't already, or the Attorney General hasn't already, is there any case law or statutes that have been upheld that is in any way similar to this, where we are asking state and local law enforcement to, to cite federal, in any area? Has that ever happened in the United States without me trying to regurgitate it? Do we have any example where this has ever happened before?
Yeah, my understanding is that particular that this is a more evolving issue. I don't think that this is a more evolving issue. I don't think that there's anything quite on point with this.
Do you have anything marginally on point? Or even remotely on point?
No.
Okay, just let me be honest, because I'm going to figure this out myself. I'm just trying to get it. I don't want to be voting without full information and accurate information.
Yeah, if I had something for you, Senator, I'd give it to you.
All right, thank you.
Thank you, Mr. Chair. So can you just give me a synopsis of what exactly we're trying to solve here?
So what the bill seeks to do is establish baseline minimum standards for when our state and local law enforcement can wear a mask, and when federal law enforcement can wear a mask when they're operating in the state of Maryland. Doing this to ensure and to instill a sense of trust with law enforcement agencies, especially given the way and the manner in which ICE in particular has conducted itself going through communities. And this has happened in Maryland, masked, armed individuals engaging with citizens, engaging with residents in a pretty violent way. And there's a lack of accountability and transparency associated when you have someone jumping out of a car armed, wearing a mask. It's terrifying. And so the bill seeks to establish some baseline minimum standards so that we can all move about this whole thing in a safe way.
So, as somebody whose profession is clothing, you're telling me that a mask, by us prohibiting that we are going to, that's in page 2 of line 4, line 18, the law enforcement agency's commitment to transparency, accountable, and public trust. So literally, a mask, prohibiting a mask, is going to address the root cause of the problem. The root cause of the problem is the disagreement that the administration, the federal administration, is applying something that has gone from one administration to the other. So what you're trying to tell me, a piece of fabric, and this is what we're doing in the Maryland General Assembly, that we are determining that a piece of fabric is going to, the prohibited of that, is going to ensure transparency, accountability, and public trust. Because what we listened to the witnesses was, you're correct. When somebody is perpetrating law enforcement, jumping out with no identification, all that kind of stuff, how is a policy going to stop that? We heard that there are a lot of people, especially females, that feel in risk of that. How is a mask? That's like putting on a cotton mask that was made in home ec and thinking it's going to have the N91 or N95 protection against anything. This particular piece of legislation is literally punting, is not addressing the root cause, and if anything, it's exasperation in. So, to talk about that, I believe we're going to be setting up an issue. So if officers do not enforce the law, can they be subject to a complaint by the public for failure to act under the MPAA?
Yeah, the instances that I've seen are generally failure to adhere to law enforcement's agency's policy or something like that. I suspect that that the other answer is going to be that it could, well, there could be a civilian complaint about.
Also, a member of the public
Sure.
has to be investigated. If they make a complaint that there was a failure to act by a law enforcement officer, it would rise to the level that they would have to investigate it.
Sure, and I don't want to debate it, Senator. I am trying to think about whether that would actually be founded or.
What I'm saying is.
Right.
Under the MPAA, any complaint by a member of the public
Right.
has to be investigated.
Right.
So this could be one where a member of the public says that they failed to comply with law and enforce it because those people saw a federal agent and the officer looked and saw them and he failed to do his job. He was derelict in his job, which is a tier 4 offense. The answer is they have, not if they would, the answer is by MPAA, they have to investigate it.
No, clearly there would need to be an investigation.
So
So
the
what-
answer about discretion earlier doesn't really apply here because it's about perspective of those in the community that see it. And if they complain, discretion's gone.
Question's still there, just it'll get complained about. But go ahead.
So
Okay,
if
no,
discretion then goes by who sees it, aren't we just inviting social media to determine how we're going to determine if an officer is guilty of some policy that, and clearly we don't have the ability to do it? Once again, while we're not addressing the root cause, and I go back to, we should be doing policy. I know it's hard, but we should be doing policy that is close to the plumb line as possible. And we should not be engaging citizens to decide if they think this violates it or not, because all we've done is just clogged up the whole situation and clouded what I see as a problem. But the fabric, the mask, is not going to solve what is in line 18, law enforcement agency committed to transparency, accountability, and public trust. If we think that's going to happen off of this, that's a foolish policy. Thank you.
Thanks. No, I appreciate it. I'll be quick. I mean, look, obviously the bill has examples of what is a mask, what is not, and several exceptions that, again, further exceptions can be developed by the MPTSC to ensure that every law enforcement officer is safe when they move about their duties and can accomplish their mission. All those exceptions are there. So in that sense, no complication for the performance of their duties. And the second sense, the second piece is that you can't have people who are law enforcement officials running around who have no identification or which agency they're associated with and who they are. And that's the trust and accountability piece that this affords. So, Senator Sidner.
I wish we could do just what you just said, but again, we would still run into the same supremacy argument that we're having here. So instead of debating masks, we'd be debating whether or not we could tell them that they have to identify themselves, correct? As I'm listening to this debate, I was going through my phone, and sorry it went off a little earlier, but I was looking just for information. So NBC News says that since September, and I'm not speaking to justification or not, but this agency has shot 12 people. Someone was just shot this morning. We have the Deputy White House Chief of Staff on October 24th said to all ICE officers, you have federal immunity in the conduct of your duties, and anybody who lays a hand on you or tries to stop you or tries to obstruct you is committing a felony. We're speaking here tonight as if we're living in normal times, and we're not. We're sitting here talking tonight as if we're the ones who are stepping out of line when we have an agency that does not abide by constitutional norms nor law enforcement norms. We would not be here attempting to pass a bill like this if they were not masking up, putting our citizens' lives in danger, putting law enforcement's lives in danger. And eventually, someone is going to be shot and killed. Some law enforcement officer is going to be shot and killed because they decide to put a mask on and attempt to kidnap one of our citizens who may be wearing and carrying and have the right justification to protect themselves. This is what we're attempting to stop by this cloth that we're talking about. And honestly, at this particular time, I'd rather pass the bill and see what the Supreme Court says. So I'll be voting for the bill.
You can, I'll make my comment.
Senator Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
I'm going to abstain.
Senator Muse.
Yes.
Senator Fulton.
I'd like to explain my vote first. Again, we have something that's brought into the discussion about shootings involving agents in the performance of their duties. And again, I would urge everyone to go back and research what Graham v. Connor says as far as an official law enforcement action in the 2020 hindsight lens. It's easy for us to sit here on the sidelines and pass judgment on these acts of officers that are out there enforcing federal law. What we're not discussing is those that are not peaceably assembling, which is a constitutional right, but they are intentionally interfering with the official acts of a law enforcement official, which is a crime. It is a crime that you can be arrested for, and it has no relevance on whether or not they have a mask on or not. If you intervene in an official law enforcement act, just like we're going to find out if a state, city, or county police officer in Maryland tries to enforce during the proper conduct and course of federal law enforcement, we're going to learn that there is a supremacy clause and that people are not staying in their lane, whether they're, if you want to go peaceably assemble and protest in that manner peacefully, the law affords for that. What it doesn't afford for you is to destroy things and to insert yourself in a legal law enforcement operation. And those are the things that I'm really disappointed to see, is that I would like to see us moving in a manner that looks to solve or find a solution about more proper identifying measures, about having their badge displayed visibly in a consistent area, having the placards on their vest consistent, having their ID number at the minimum, to where if someone sees something that's not enforceable, even with a mask or not, there's still the identifying parts there to lodge an appropriate complaint as a concerned citizen. But that's not what we're doing here. We're not looking for a solution. We're looking to virtue signal about something that is a standard that is not applicable through the supremacy clause. We're creating an opportunity for a conflict between a federal agent in the performance of his duties and a local Maryland law enforcement official to comply and take away his discretion by the MPAA to enforce this matter and put himself or herself in harm's way in the public eye, because the immediacy is the important part of this. So very disappointed to see this body move something so reckless instead of looking to find a solution that we all really do seek. I do believe that, but without the proper avenues to do it, we're just going to go after masks instead of looking for a really reasonable solution. And with that, I say no.
Senator James.
Thank you, and I'd like to explain my vote briefly, too. The Senate President was with me when I had a little event in Annapolis, and I said to him and to the public, I don't ever vote against a bill that might be coming from the majority, because I wish that it fails. I hope it doesn't succeed. I only vote no when I think, with a lot of research and thought, that this is not going to solve the problem, and in some cases may make the problem worse. And I'm never rooting for the minority when they're voting in opposition to the majority, unless they feel like I do, but I don't think they do often. I think it's a different philosophy. I want us to succeed. That's always where I'm coming from. But here's why I can't support the bill, just very briefly. I'm in favor of the first part of the bill. I think we should have a uniform policy and get it out there and work cooperatively and publicly to get this policy accepted and adopted as best we can volitionally. But I don't want to ever knowingly potentially increase the risk for any harm to local, state, or federal law enforcement. And I do not ever want to intentionally create a situation in law that could elevate tensions and risk that not only could hurt law enforcement, but the surrounding public in any of these incidences. And finally, just my own unexpert research on the Google machine, it's so evident to me that there's a lot of law that deals with mandatory identification. Nothing about masks, but mandatory identification. Maryland has it, the feds have it. It's all over the country. If you started with the idea of policy obliging all law enforcement, even though we might be running up against the supremacy clause, that talks about asking and acquiring well displayed identification, even if someone was doing a mask for fear of doxing. I think you'd first be rooted in a lot of data on public safety, and also just historically, it is risky for both law enforcement and for citizens for someone to come up and just claim to be law enforcement, and they're not, or they potentially couldn't be. I think you'd be on pretty good ground that the courts would be amenable to trying to figure out how to support our law if we were focused on that public safety aspect. So again, that's not what the bill does. I've support the first part of it, and I regret that I cannot support this entire bill, because I regret it was not amended in a way that I think we could have easily done, and it would have been more effective. All right, thank you, Mr. Chairman.
Senator Henson.
To explain my vote is yes, but I just want to explain it so the exercise that we're having about what might happen, in some ways it's not just theoretical here. In Anne Arundel County, we did have on Christmas Eve an incident where there was ICE enforcement activity, and in that enforcement activity, there was people were shot at, and there was conflicting reports about how that shooting happened. The ICE officer said that the person that they were trying to apprehend in a targeted enforcement, that person accelerated their vehicle after they smashed their window on Christmas Eve, and that then they shot at the vehicle and someone was injured. The Anne Arundel County Police Department did an independent investigation and came back and said the facts happened a little bit different than that. What we see is we have asked a lot of our local law enforcement officers by way of transparency, by way of accountability, and I think we are seeing some of the gains of that pay off, and I think we saw that in the independence of the Anne Arundel County police officers and their investigation there. And I think that if we are asking for that transparency and accountability of our local law enforcement officers, and they're stepping up to give us that we certainly should be asking for some parity when it comes to their federal partners who are here and operating similarly in our state. I think this is a first step, and I think that a lot of people identified a lot of things that we could do to add to that transparency in building the good faith that builds the type of good law enforcement that we want to see there with our federal partners. So I am voting yes for the bill, but I'm not voting yes as if to say that there's nothing else that we could or should do, but voting yes with the acknowledgement that this bill will, continue to have aspects that have to be worked out, and that we will continue to work on this policy to make sure that we are building the good faith and that the lessons that we've learned about transparency and accountability translate to our federal partners as well. Thank you.
Senator Love.
I vote yes, and I will join in the chorus of those who are explaining their vote. I will say that I'm voting yes because we should not have masked law enforcement on our streets. And for all of the reasons that Senator Sidner said, and also for the reasons that Senator Henson said, I believe this is the first step. I think there are a lot of other things that we need to do because we are not in the world that we are discussing in this theoretical discussion that we've been having, as Senator Sidner said. So I vote yes. Thank you.
Senator McKay.
Nay.
Senator Charles.
Yes.
Senator West.
I guess I'm going to also join the chorus of those who are explaining their votes. I totally agree with the first part of this bill, which says we should have a policy against wearing masks. I think the idea that policemen wear masks and walk around looking effectively like these stormtroopers in Star Wars, and you can't tell who they are, and they're unrecognizable, I think that's reprehensible. And I've never noticed a Maryland police officer to wear a mask unless it was freezing cold or he has a health problem. So it would merely put into law what I've always observed here on the streets in Maryland. Our officers don't wear masks. Where I run into a problem is the second half of the bill. I was planning to vote in favor of the bill because ICE doesn't currently have a policy that either requires masks or doesn't require masks. But I'm now persuaded, having listened to Bill Ferguson's long conversation with the chair of the committee and committee counsel, that fact. Bill Ferguson? I'm sorry, Bill Folden. Bill Folden. You know, BF.
Sorry, Mr. President.
So I see what is going to happen going down the road, which is the local officers are going to go up to ICE and say, you're violating our statute. I need to have your name and address. And the ICE officers are going to say, we are federal officers doing our duty. We don't have to answer those questions at all. And the local officers are going to say, well, then you're obstructing justice. I'm putting you under arrest. And the ICE officers are going to respond by saying, you're obstructing federal officers. I'm putting you under arrest. And we're going to have two squadrons of police officers, each trying to put the other squadron under arrest. This is bad. It's not going to end happily. I would have far preferred this bill to have charged the Attorney General in the event it turns out people are operating in Maryland wearing masks in violation of the bill, with commencing an injunction proceeding in federal court to get an injunction against the officers that are operating in Maryland wearing masks. Then the court would handle it, then it would be appealed, and then possibly it would go to the Supreme Court. And the courts would resolve the issue rather than groups of officers in the streets fighting against each other. I believe this bill will result in officers fighting against each other in the streets. I can't sign on to it, and therefore I have to vote no.
Chairman Smith.
Yes.